I didn't find out the HOA wanted me gone through a letter, a meeting notice, or even a fine. I found out by accident, overhearing a conversation that wasn't meant for me. Two board members were standing near the mailbox cluster, talking in low voices, assuming no one else was around. My name came up, then my address, then the phrase that made everything click into place. We just need him out, one way or another. That's when I knew this wasn't about rules anymore. I wasn't an HOA member. Never had been. My property sat right on the edge of their jurisdiction, a clean, legally surveyed slice of land that predated the HOA by decades. I followed county law, paid my taxes, kept my place maintained. The problem wasn't compliance. The problem was control. They didn't like that I couldn't be fined. They didn't like that I didn't attend meetings. They didn't like that I said no and it actually stuck. At first, the pressure was subtle. Anonymous complaints about noise. Notes about unapproved structures that didn't exist. A letter warning me about landscaping standards that weren't legally enforceable on my land. Each one was designed to test whether I'd fold. I didn't. So they escalated. Suddenly, survey stakes appeared near my fence line, bright orange, planted overnight. Then came a notice claiming my driveway encroached on HOA-managed land. After that, a warning that future access could be restricted if the issue wasn't resolved. No citations. No case numbers. Just threats dressed up as authority. That's when I pulled my own records. Original plat maps. County surveys. Recorded easements. Every inch of my property was documented, stamped, and verified. According to the county, my boundary wasn't questionable, it was boringly clear. But HOAs don't thrive on clarity. They thrive on pressure. And pressure only works when you're unprepared. The final straw came when I received an email, not from the board, but from their attorney, suggesting it might be simpler for everyone if I considered selling. Not moving a fence. Not resolving a dispute. Selling. As in leaving. That was the moment I stopped reacting and started planning. If they wanted a property line dispute, I'd give them one. But not the kind they could bully their way through. I requested certified boundary verification from the county. Filed formal notices documenting harassment. Installed visible markers exactly on the legal line. And then I sent one calm, polite email to the HOA board. Any further action affecting my property will require written justification tied to recorded jurisdiction. Please preserve all records. Silence followed. Not because they'd backed down, but because they were regrouping. They thought the property line was a weakness. They thought proximity meant vulnerability. They thought I'd get tired and leave. Instead, I turned that thin strip of land into the most legally fortified line they'd ever crossed. And they had no idea what was coming next. Once I realized they weren't bluffing, I stopped treating this like a neighbor dispute and started treating it like a case file. The first thing I did was lock the timeline down. I requested certified copies of every survey tied to my property, original plats, boundary adjustments, easements, right-of-way records. Not PDFs. Not screenshots. Stamped, recorded documents straight from the county recorder's office. If this ever went to court, I wanted zero ambiguity. While I waited, the HOA made their next move. A formal, boundary concern letter showed up in my mailbox, this time on official letterhead. According to them, a new internal review suggested my fence, driveway, and a portion of my landscaping were within HOA-managed common space. They gave me 30 days to correct the issue or face enforcement. Enforcement from an HOA that had no jurisdiction over me. I didn't respond. Instead, I hired a licensed surveyor. Not cheap, not fast, but precise. He spent 2 full days on my property, setting pins, measuring angles, cross-referencing county GIS data. When he finished, he smiled and said, "You're not just outside the HOA. You're not even close." Better than I expected. We installed permanent steel markers at every corner of my lot, flush with the ground but clearly visible. Then we ran a high-visibility boundary line exactly where the law said it belonged. No exaggeration. No buffer. Just facts, painted bright. That's when the HOA panicked. Board members started driving by slowly. taking photos, stopping to inspect from the street. One even knocked on my door pretending to be friendly, casually asking who authorized the survey. I told him the county did. The next email came fast. They claimed my new markers were provocative and could confuse residents. They demanded I remove them. I replied once. All markers reflect recorded boundaries. Removal would constitute tampering with surveyed property lines. Please advise if you wish to proceed with that in writing. No response. A week later, I received notice of a special HOA meeting to discuss boundary enforcement strategies. Not inviting me. Not notifying me officially. Just careless enough that a neighbor forwarded the agenda. That agenda told me everything. They were discussing access restrictions, legal pressure, and most importantly, whether they could force compliance through nuisance action. That was the moment I escalated for real. I filed a formal harassment and jurisdictional overreach complaint with the county. Attached every letter, every photo, every timestamp drive-by. I CC'd the HOA's attorney. Then I sent one final message to the board. Any further contact outside legal counsel will be documented as harassment. My property line is no longer a discussion, it's a recorded fact. That's when the tone shifted. Not because they respected me, but because they realized the property line they were trying to erase had turned into a paper trail they couldn't outrun. The county moved faster than I expected. Within 2 weeks, I received confirmation that my complaint had been accepted for review. That alone changed everything. The HOA's casual intimidation tactics, drive-bys, vague emails, anonymous complaints, suddenly stopped. Not because they felt bad, but because silence is what people choose when they know their words might become evidence. That didn't mean they were done. It meant they were lawyered up. Their next move came through certified mail. A thick envelope from the HOA's legal counsel outlining their position. According to them, historical usage and community reliance gave the HOA implied rights over parts of my land. They didn't cite statutes. They didn't cite case law. They cited assumptions. I forwarded the letter to my attorney. His response was a single sentence. They're fishing. We drafted a reply that was short, cold, and devastating. It included the certified survey, the county boundary verification, and a clear warning. Any claim of implied rights was contradicted by recorded law. We also demanded they preserve all communications related to my property, emails, meeting notes, internal messages. That last part rattled them, because preservation requests mean discovery. A few days later, I got a call from the surveyor. You might want to see this, he said. Turns out, while reviewing adjacent plats, he noticed something strange. The HOA's internal map, the one they'd been using for years, had been altered. Boundary lines were subtly shifted. Not enough to raise eyebrows at a glance, but enough to bring several non-HOA properties, including mine, inside their control. Whether it was intentional or incompetence didn't matter. It was wrong. We included that finding in our next filing with the county, along with a request for audit. That's when the pressure reversed. Instead of pushing me, the HOA started defending itself. Board members stopped making eye contact. Emails were carefully worded. The special meeting was quietly canceled. And for the first time, I saw something I hadn't seen before. Fear. Neighbors started asking questions. Why were boundaries changing? Why were people being fined for land the county didn't recognize as HOA property? A few homeowners reached out privately, asking how they could verify their own lines. I told them how. The county scheduled a formal review session, open to the HOA, my attorney, and county officials. Not a trial, not yet, but a recorded proceeding with real consequences. The HOA showed up with binders. I showed up with facts, maps, surveys, records, a clean timeline. And right there, in a fluorescent-lit county conference room, the truth became unavoidable. The HOA hadn't just overstepped once. They'd built their authority on a boundary line that didn't legally exist. And when the county officials started asking how long that map had been in use, the HOA's attorney stopped taking notes. Because at that moment, everyone in the room understood something critical. This was no longer about me. This was about how many property lines had been quietly crossed before anyone pushed back. The county officials didn't raise their voices. They didn't accuse. They didn't need to. They just asked questions. Simple ones at first. Who created the HOA's internal map? When was it last updated? What source data was used? Each answer from the board sounded less confident than the last. Dates didn't line up. References were vague. At one point, the HOA president admitted the map had been adjusted over time to reflect practical boundaries. Practical. The county rep paused, then said calmly, "Practical boundaries aren't legal boundaries." That was the moment the room shifted. My attorney slid forward a comparison. 2 maps side by side. On one, the official county plat, crisp and clean. On the other, the HOA version, with lines drifting just enough to swallow up neighboring lots. The difference was undeniable. "This isn't an interpretation issue," my attorney said. "This is misrepresentation." The HOA attorney objected. Weakly. The county official didn't even look up. "Objection noted," he said. "Now explain why residents were fined based on this." Silence. One board member finally spoke. "We didn't know." "That's not a defense," the official replied. "It's a liability." The review expanded on the spot. What had started as my complaint turned into a broader inquiry. The county requested enforcement records tied to the altered boundaries, fines, violations, access restrictions. The HOA was given 10 business days to produce everything. When the meeting ended, no one shook hands. 2 days later, the HOA sent a notice to all residents suspending boundary-related enforcement, pending clarification. That wording didn't fool anyone. It was a full stop. Neighbors began comparing notes. Stories surfaced. Fences forced back. Gardens removed. Driveways corrected. All on land that, according to the county, might never have been HOA-controlled at all. The board fractured. One member resigned quietly. Another hired his own attorney. The president stopped responding to emails entirely. And then, late one afternoon, I received a call from the county investigator assigned to the case. "We're escalating this," he said. "There's enough here to warrant a formal audit." An audit. That word does things to organizations like HOAs. It means documents don't stay internal. It means decisions get timelines. It means responsibility stops being theoretical. For the first time since this started, I felt something close to calm. Not relief. Not victory. Control. Because the property line they'd tried to erase had turned into a fault line running straight through their authority. And the ground was starting to move. The audit took 3 months. 3 quiet, uncomfortable months where the HOA stopped acting like an authority and started acting like a defendant. No fines. No notices. No surprise letters taped to doors. The board meetings, when they happened at all, were closed, short, and carefully worded. The confidence they once carried like armor was gone. When the county's findings were released, they weren't dramatic. They were devastating. The report confirmed that the HOA's internal boundary map had no legal standing and had been used improperly for years. Multiple properties, including mine, had been subjected to enforcement outside HOA jurisdiction. Fines were issued without authority. Threats were made without standing. In some cases, property owners had been pressured into altering land they legally owned. The county ordered corrective action. Every boundary-based violation tied to the false map was invalidated. Refunds were required. Records had to be corrected. And the HOA was formally warned that any future misrepresentation of jurisdiction could trigger penalties far more serious than fines. The board didn't survive intact. The president resigned the same week the report went public. 2 more members followed shortly after. An interim board was installed under supervision, and the first thing they did was send out a carefully written letter acknowledging significant governance failures and promising transparency going forward. I received one final message from the HOA's attorney. It wasn't a threat. It wasn't an argument. It was confirmation, in writing, that the HOA would never again assert authority over my property and that any future contact would go exclusively through legal counsel. I didn't frame that one. I filed it. Neighbors started treating the property line differently after that. Not as a gray area. Not as something flexible. but as what it always was, a fact. A limit. A line that mattered. A few even thanked me, quietly, for pushing back when no one else felt they could. I didn't set out to start a war. I just refused to disappear. The HOA thought proximity meant control. They thought pressure would make me fold. They thought the property line was a weakness they could exploit. Instead, it became the place where their authority stopped. And here's the part they never understood. You don't win against overreach by being louder. You don't win by threatening back. You don't win by hoping it goes away. You win by documenting everything. You win by knowing where the line actually is. You win by standing exactly on it and not moving. Because once power crosses into land it doesn't own, it stops being power. It becomes a liability.